This is a lecture from Open Tuition. For the free lecture notes that go with this podcast, please visit opentuition.com.
Directors removal is where we are, page 81. Ordinary resolution. Just vote them off. But there is something special about it. And the special thing about it is the notice period which is required. It's just an ordinary resolution, but it has special notice. It is not the same as a special resolution. A special resolution is 75% majority, with 14 days notice, unless it happens to be at an annual general meeting, because the general meeting needs 21 days notice. It is not the same as a special resolution. We've had two special resolutions so far, two specials resolutions. What were the two special resolutions? Change the articles and getting married. Yeah, changing the name. Change the name requires a special resolution. Changing the articles requires a special resolution. This is not the same. This is an ordinary resolution. It has to be, think about it, it has to be as easy as possible to get rid of a director. If the majority want the director to go, then the majority wish shall prevail. The majority wish shall beat the minority's wish. All right? The special notice is defined as being 28 days' notice is given to the company, and the company puts this resolution on the agenda and must notify the shareholders not later than 21 days before the meeting. So it's a two-part requirement, 28 days to the company and then the last 3 weeks of that 28. It's not 4 weeks and then 3 weeks. It's 28 days before the meeting and 21 days before the meeting. So within a week, the company must give notice to the members. Now that week requirement, that 7-day requirement, is there for a reason. And the reason is that some aggrieved shareholder wants to get rid of a director. Maybe they've had a personal argument. Maybe they live next door to the director and the director keeps throwing his grass cuttings over the fence into his garden. Maybe some reason, some silly reason maybe. But the shareholder gives notice to the company. And the company then immediately tells the director and says, oh, we've had indication that somebody wants to remove you and we have to put it on the agenda, but you now have got 7 days to prepare your case that you can present to the shareholders and say, these are the reasons why I think I shouldn't be removed. And these are called, and it's an expression which I shall use more than once, these are called written representations of reasonable length and not defamatory in nature. Written representations of reasonable length. I'll explain defamatory for you. Written representations of reasonable length. Don't make me write representations out in full. Of reasonable length and not, and it's a strange word, defamatory in nature. And to defame, the verb to defame, is effectively to show bitterness or to character assassinate, to defame somebody. I could defame any one of you and say, I saw you in town last night, this morning, at 3 o'clock, drunk. You were drunk, not me. I could say that, and I'm defaming your character. I am bringing your reputation down in the eyes of others. So defamatory is then character assassination, it's bitterness. So a director who is proposed to be removed by a shareholder asking for a resolution, he can't write back and say, this shareholder is carrying out a personal vengeance against me just because I throw my grass cuttings over the fence into his garden. He's always been an idiot. He will continue to be an idiot. every time there's a full moon he howls and keeps me awake. I mean, it's going on, and character assassinating would be defamatory. So to defame is to be nasty about someone. These directors, when they are proposed to be removed, have got the opportunity to make their written representations of reasonable length, so long as they're not defamatory. Now, the company is the ones who decide, because he's going to write these representations out and give them to the company. The company or the directors will read these representations of reasonable length and ask themselves, is this defamatory? And they will go to the court and ask for relief from the court to say that you do not have to distribute these because they are defamatory. So any justification that the directors may claim for not circulating these written representations of reasonable length would be under the context of them being defamatory. But really they should be asking the court, do you consider these? We think they may be defamatory. Should we circulate these representations or not? Reasonable length, you know what reasonable length is. Reasonable length is length which is reasonable, but in the context of written representations of reasonable length, these shall not exceed 1,000 words. Reasonable length in this context is 1,000 words. Not exceeding 1,000 words. I gave you the illustration of the neighbour with the grass cuttings coming over his fence, but actually there is a more restrictive condition that has to be satisfied. In order to prevent silly actions, in order to prevent the grass cutting receiving neighbour, some frivolous, some silly, some minor argument that he's had with the director, there is the requirement that if a shareholder wants to propose a director for removal, then he's not able to unless he can get together some friends. And he needs to have not less than 100 members holding not less than £100 worth of paid-up capital, on average. So £10,000 worth of share capital. So 100 members, each holding, on average, not less than £100 worth of capital. So it's not just the grass-cutting person. He can't do it. Well, there are circumstances when he can. But generally, in a big company, your national telephone company, you'd need to get together 100 members holding not less than, on average, £100 worth each, in order to be able to insist that the director should include this on the agenda. And that request has to be given to the company no later than 6 weeks before the meeting where you want the resolution to be heard. So special notice is 28 days, 21 days. But if we're in the position of having to satisfy 100 members £100, then we must give the request not later than 6 weeks before the meeting is to be held. This is big companies. Private companies, just you and I have an argument and we say, listen, we're falling out, one of us has got to go. So you in a private company, normally, private companies, in my mind, I have a vision of private companies, just two people. Often it's husband and wife. And husband and wife, as happens in life, they do drift apart. And if they drift apart so far, then one will say, I'm divorcing you, you can have the shares, I'm leaving. Or I want the shares because you're useless, or whatever. So private companies, in my mind, a private company tends to be just 2 or 3 people are involved. And you will negotiate. You'll say, listen, this isn't working. You're going to have to go. There are some big, I'm talking big private companies, enormous, household name private companies in the UK. I'm thinking of one called the John Lewis. It's called the John Lewis Partnership, and it's a private company. And the John Lewis Partnership shares their profits amongst their employees. Because it's a private company, it's not shareholder orientated, and they share their profits out by way of bonus amongst their employees. So there are some enormous private companies, But for the most part, private companies are either me on my own, or me with my partner, or me with my wife, or me with children, or whatever. It's normally small organizations. Okay, notice to the registrar. Special notice is one of these things that you have to deliver a copy of the special notice to the registrar. The notice says, notice is hereby given that in 21 days' time we're going to have an other general meeting. The purpose of the meeting is to discuss and, if thought fit, to remove Gunuta as a director. So that notice, that special notice, a copy must go to the registrar. And of course, the resolution, the ordinary resolution, which is then passed or not, the ordinary resolution which does remove Gunuta, a copy of that must go to the registrar as well, together with a notification, a formal notification that Gunuta is no longer a director. So that must go to the registrar. Weighted voting rights can make removal impossible. We've already looked at the question of the case Bushell and Faith. Do you remember the two older sisters and the little brother? That weighted voting rights can make removal impossible. What are you looking?
But what is the difference between registrar and register?
Registrar is a person, register is a thing. A register of members. And you get a number of confusing titles in company law. For instance, there is the Registrar of Companies. And this is the person in Cardiff, this is his woman in Cardiff, who's in overall control. She's an employee of the Department of Trade, and she's in overall control of keeping the records of all the companies in the UK, as in England and Wales. But then you also get the company's registrar, and that's a different person. The company's registrar is a person who looks after the records of an individual company. And that's why you've got the different spelling. That's why the second one is an individual company, whereas the first one is all the companies. So the company's registrar, I'll keep it simple, is a person whose responsibility it is to maintain the register of members, which is when you were at school, when you were a schoolgirl, and your teacher at the start of the day said, Benita, are you here? And you say, yes, I'm here present. Then they will tick off a register to show your attendance. So a register is a book. It's a record of attendance or people or members or loans. You have a register of loans and debentures. You have a register of directors, a register of secretaries, a register of debentures, a register of members, a register of director shareholdings, lots of registers. It came up in the last exam. It came up in the December exam. It said, what are the main, now that's a difficult question, what are the main registers which must be kept by a company, and what are the contents? That's an enormous question, because I can think of around 10 registers that must be kept. It's only a 10-mark question. I can think of 10 registers which must be kept, and then to start putting in the contents of those registers, all in the space of 18 minutes, is a huge question, a very difficult one. The examiner, I think, would be fairer to say, what is a register of members and what does it contain? What is a register of directors and what does it contain? But to say what are the registers which a company must maintain is, in my view, a very, very wide question, a very long and very difficult question. But that, I think, does that explain the difference between a register and a registrar? Yeah? Okay. Registrar of companies is this woman in Cardiff. She's looking after all the records of all the companies. A company's registrar is the individual who's looking after the statutory books, these registers which must be kept. They're called the statutory books. Now, I said it's a person, but in fact, if you think about the registrar for your national telephone company, where you've got thousands and thousands and thousands of different members, it's much too much work for an individual person. So instead of having an individual to serve as the company's registrar, what companies often do is they will appoint a professional organisation whose sole purpose in life is to maintain the statutory records of a number of different companies. And I'm going to say all the high street banks, all the SCBs and the Swedbanks and the Crowdplus banks, all the banks in the UK will have their own registrars departments. And so if you have a bank account with Lloyds Bank or with HSOB, then they may say, we will look after your statutory records for you at a cost. And so you pass the responsibility over to a professional organisation. It's too much for an individual, unless you're talking about a small company, in which case it's easy. No, the stock exchange don't keep registration details of companies. The stock exchange will... Don't forget, it's only, say, 10,000 companies who are subject to the rules of the stock exchange. Out of our million, there's only about 10,000 of them. And even then... Sorry, I said 10,000. Only 1,000 would be quoted, around 1,000. If you get a copy of the Financial Times, not here, because the Financial Times version that you get here doesn't have this detail that you get in the UK. In the UK, if you buy a copy of the Financial Times, the last 2 pages, and it's the inside of the back and the one facing it, and it's a broadsheet paper, it's not a little thing. It's just full of stock exchange quotations of all the companies on the stock exchange, showing the daily movement and the price-earnings ratio and whether it's an ex-dividend, whether their dividend is to be declared, what the buying and selling price is, what the high is for the year and the low for the year. And all that detail is produced on a daily basis in the Financial Times and other quality papers. So there's only about 1,000 of them that the stock exchange have. And quoted companies have to report on a regular basis to the stock exchange. Some annually, some half annually, and some quarterly have to report to the stock exchange with their interim accounts. But that's not what we're talking about. This has nothing to do with company registrars. Okay?
Changes of the shareholding. Somebody takes the register of the shareholders.
There shall be a register of shareholders, and the annual return every 3 years has to give a full list of the shareholders, but that goes to this top person, that goes to this woman in Cardiff. It doesn't go to the stock exchange.
Okay. Here we have different...
Well, yes, okay. Here we're different, but dare I say, the paper's called English law. So notice to the registrar, weighted voting rights, bushel and faith, and the company may have to pay substantial compensation to any director who is removed. Again, corporate governance comes into that particular area. Corporate governance says that you should not have a director's service contract which involves you potentially having to pay more than 1 year's salary in the event of removal of the director. You should not have to pay, if you remove a director and you have to compensate for him losing office or her losing office, you should not be contractually bound to pay more than 1 year's salary. Because otherwise, think about it, we've got our 3 directors over here, and one of them, we don't want Jana anymore. She's got a 5-year contract. She's only just started, and we've just discovered that she's not competent. So let's cut our losses. Oh, fine. But if we cut our losses, we're breaching her contract, and we have to pay her 4.5 years' worth of salary. It's possibly cheaper for us to let her continue, because she's not going to cost the company as much as 4.5 years' salary. Well, she is, because we're going to have to pay her, but we'd have to pay her if we sacked her anyway. So the potential loss from keeping on an incompetent director should not be so great that you feel it's better to keep them on and keep paying them than to have to pay this compensation.